All right, good afternoon. Thank you for being here. Welcome to this Supreme Court Term in Review panel. Some of you may be new here. Some of you may have been coming to this event for years. This event started here at Mayor Brown, sponsored by PILI, the ACLU, and ACS, back around 2008, 2009, something like that. And we were here consistently every year. The pandemic got in the way, and we've been sort of wandering in the wilderness since 2019, but we're back, and we're really happy to be back at Mayor Brown and in person for such a terrific turnout. So thank you for being here. Again, this event is co-sponsored by the ACLU of Illinois, the American Constitution Society, Chicago Lawyer Chapter, the Public Interest Legal Initiative, Public Interest Law Initiative, PILI, and Mayor Brown. So thanks to our co-sponsors. Thanks also especially to Kayla Flanagan and Emily Scott from the ACLU, Megan Paulus and Peggy Lee from ACS, and Heidi Dabrowski and her team here at Mayor Brown. Administratively, I need to let you know the event has been approved for 1.5 hours of CLE credit. You can sign up for the CLE at the table. Those of you joining online, we in addition to the people in the room, we also have a substantial audience online. We're hybrid this year. You should have received the information, the CLE information by email. The first thing I'm supposed to do is give you one of the two codes for CLE at the beginning of the, so this is something you have to enter in order to get the credit. So the first code is Barbie, B-A-R-B-I-E. This wasn't my idea. I didn't make these up. You could probably guess what the second one is, but I'm not officially allowed to give the second one until we are in the middle of the panel. So our format here is we're really fortunate to have 5 extremely skilled and well-known and talented practitioners and academics, and some people who are or have been both, to talk to you about, I think, a total of 7 cases from the Supreme Court term just completed. Let me introduce my fellow panelists quickly, and then we'll go in the order in which I have introduced them. Starting from this side, Aziz, who is the Frank and Bernice Greenberg Professor of Law at the University of Chicago Law School and a member of the ACS National Board of Directors. Stephen Schwinn, Professor of Law at the University of Illinois Chicago Law School and a member of the ACS Chicago Lawyer Chapter Board of Visitors. Michelle García, the Deputy Legal Director of the ACLU of Illinois. Carolyn Shapiro, the Associate Dean for Academic Administration and Strategic Initiatives, co-director of the Institute on the Supreme Court, and professor of law and ACS faculty advisor at Chicago-Kent College of Law. And finally, Mike Scodro, a partner and member of the Supreme Court and appellate practice here at Mayor Brown. My name is Steve Sanders. I teach at Indiana University at the Maurer School of Law in Bloomington, but I'm fortunate enough to be able to come back each year and do this. This event, as I said, started when I was a lawyer here more than 15 years ago, and we're really pleased that we've been able to keep it going. So I think without further ado, I'm going to ask Aziz to go ahead, and each of the panelists have been given strict time limits that I will enforce in order to get you out of here by 1:30 and also have some time for questions and answers after their presentation. So the panelists who are talking about one case will each get 8 minutes, and the panelists who have been asked to talk about 2 cases, that's Steve and Mike, will get 13 minutes altogether. And so with any luck, that'll get us a little past 1 o'clock, and we'll still have some time for your questions. So Aziz, please take it away. And you'll need to.
Thank you very much, Steve, for moderating. Thank you to ACS, the ACLU, to which I also have an institutional affiliation, and all the other organizations, and especially Mayor Brown, for hosting. I will try and stick to my 8 minutes. I'm not sure Steve really understands what it means to try and cut off an academic. We'll find out. My task is to talk you through SFAA v. Harvard, the consolidated cases challenging affirmative action both in private and public institutions that were decided at the end of the Supreme Court term. Let me start by telling you or reminding you what the law it was prior to SFAA pursuant to the Equal Protection Clause. So with respect to race, there were two tests for challenges under equal protection. The first is called strict scrutiny. Strict scrutiny was triggered when the government uses a racial classification, and upon that required a showing by the government of a compelling state interest that was narrowly tailored to the vindication of that interest. The second test, described in a series of cases from Washington v. Davis onward, concerned government actions that were motivated by an invidious racial intent. Previous challenges to affirmative action had been decided upon under the first prong, under the strict scrutiny test for equal protection violations. And in a series of cases culminating initially in a pair of challenges to the University of Virginia's policies, and then in a pair of subsequent cases concerning the University of Texas, the court had upheld affirmative action policies in state institutions on the ground that those policies satisfied strict scrutiny. The relevant government interest in those cases that was recognized was termed diversity. This was an idea that was introduced in an important opinion by Justice Powell, Lewis Powell, in the Brackeen case, which concerned the medical school at UC Davis. By the University of Texas cases, both called Fisher, diversity was understood in terms of the university's interest in obtaining a, quote, critical mass of minority students for the purposes of realizing the benefits to education from diversity. It's the state of the law. Let's talk about how the law changes. SFAA brought challenges both to Harvard and UNC Chapel Hill's educational admissions use of diversity. The court consolidated those cases, and in a decision by Chief Justice Roberts, struck down both the Harvard and the UNC policy. There are some procedural priors to the case, for example, the standing of SFAA to bring the challenge. The one important procedural point that I would note is this. The opinion is written as if both Harvard and UNC Chapel Hill are subject to the Equal Protection Clause. That's not the case. Harvard is not a state actor. It's subject to Title VI of the Civil Rights Act, which subjects educational institutions that receive federal funds to similar but not necessarily identical rules. But the opinion is written as if the practice of affirmative action at Harvard is subject to constitutional scrutiny. It's a very odd opinion in that sense, and I'll come back to why I think that decision was made in a moment. The core of the opinion is the core of the majority opinion is the holding that the pursuit of diversity by the creation of a critical mass of minority students is no longer a compelling state interest. The majority focuses upon at least three reasons why that's the case. First, the majority focuses upon the incoherence of the diversity ideal. Second, it focuses upon the difficulty of measuring the achievement of educational benefits from diversity, and in particular, the absence of any clear point at which diversity yields the necessary educational benefits. And then third, the majority focuses upon the incoherence of the underlying categories, the underlying racial categories. This is something that Justice Gorsuch picks up on in dissent. The court therefore invalidates the use of race as a categorical sorting device, but in an important last paragraph says that universities are permitted to look to or take into account race when it is part of a candidate's personal statement, relevant and is brought up in a way that is relevant to that candidate's particular pathway to the university. So the outcome of the case is that candidates can, that race can still play a role in admissions, but the role has to be in relation to the particular candidate. What's striking about this opinion? First, if the court was serious about the reasons for which diversity is not a compelling state interest, it would be forced further to conclude that the achievement of public safety in cases involving policing or national security in cases involving the intelligence services or the military were also not compelling state interests because they are subject to precisely the same criticisms that the court leveled at diversity. They don't have a stopping point, they're hard to measure, and they often rely upon incoherent categorical grounds. Second important point to make. Although the court identifies the possibility of racial considerations playing a role in the consideration of individual applicants, the court's opinion also warns that the court will not accept the use of proxies or shadows for racial quotas. It's not clear how those two things fit together, and it's quite possible to imagine future challenges to university admissions program that focus not upon the decision-making process, but upon the absolute ratio of Black to white or Hispanic to white candidates in an entering class. And if the court treats those, I realize I'm at time, I'm at the end of my sentence. If the court treats those numerical ratios as proxies for impermissible intent, the effective consequence of the opinion will be to freeze in place the present racial composition of college and graduate school classes in a way that perpetuates the exclusion of not just Black students, but also Hispanic and Asian students. So one should read the opinion in light of that last paragraph as an affirmative, as an exercise in affirmative action for those who already benefit from university admissions.
That was a very long sentence. Just kidding.
That was one sentence.
Okay. Next up, Steve Schwinn.
Thank you, Steve, and thanks again to the American Constitution Society, the ACLU, and our friends at Mayor Brown and on the panel. It's a real treat to be back live in person at Mayor Brown. This is very exciting, and I love the new setup. It makes eating much easier and much more comfortable. It just feels much less formal. So I'm talking about a couple of cases that came down this term dealing with the separation of powers and administrative agency power from the Supreme Court. The Sackett case dealing with the Clean Water Act, and Biden versus Nebraska dealing with President Biden's student loan forgiveness program. And I'll talk about each of those in a second, but at first I want to tell you about why I'm excited to talk about them. And it has nothing to do with the results in the case. I think the results are abysmal. But I'm excited to talk about them because we're seeing a couple of trends accelerate in these cases and really kind of come to a point. And I think we're actually going to see them accelerate more in coming terms, and I can talk a little bit about that now and in Q&A. But what we're seeing really, in my view, with these cases are four things in particular. We're seeing a focus on textualism by the court in a kind of hypertextualist and results-oriented way. Now, that's not a news story, but we're seeing that trend accelerate on this court, this supermajority 6-3 court. We're also seeing the court, second, we're seeing the court use history in an opportunistic and results-oriented way, and really just a plain old twisted way, right? And we saw that last summer with the rulings on abortion and gun rights. We're seeing it again this year in somewhat more subtle ways in the cases that I'll describe here in a second. But again, an accelerating trend and something that I think we ought to worry about and keep our eye on. Then with regard to these two cases in particular, we're seeing a couple of things that accelerate a trend on this court attacking the administrative state. And we will see more of this in future terms starting next term. I'll say more about that in a second. But one trend that we're seeing is simply the court moving to eviscerate the power of administrative agencies. And it's doing that on a multi-front way. It's attacking the removal power, removal restrictions imposed by Congress on independent agencies. It's authorizing the president, as we saw in the Trump administration, to use the appointment power in new and dramatic ways in the name of a unitary executive. And it's attacking the independence of the structure of federal agencies. We're going to see a case next term where the court is considering the funding structure of the Consumer Financial Protection Bureau, a really important case that could have very deep implications for other independent agencies within the executive branch. And then finally, and this is a most disturbing trend to me, we're seeing a court that is both the police of separation of powers, but also a part of separation of powers, right? Of course, the court is part of our three-part government. We all know that from our civics class in high school. And yet the court is almost willfully ignorant of that fact when it purports to police separation of powers. And the trend that we're seeing is the court really moving to grab power away from both Congress and the administrative agencies, the executive branch, in ways that really are stunning in my view and ought to cause us great concern. And again, I think this is a continuation and acceleration of a trend, but I think we're going to see a lot more of it in future terms. So let me talk about the couple of cases that I've been assigned. The first one is Sackett versus Environmental Protection Agency. And this deals with the authority of the Environmental Protection Agency and the Army Corps of Engineers under the Clean Water Act. And just to kind of contextualize this a little bit, you might remember that the court issued a ruling on the Clean Air Act last summer and came up with this new doctrine, the major questions doctrine, to strike the EPA's regulation under the Clean Air Act. Well, we're seeing a kind of similar ruling under the Clean Water Act in the Sackett case. The case involves the EPA's authority to regulate wetlands that are connected to interstate waterways under the Clean Air Act, but may not be connected on the surface. Some of these wetlands, as we know, right, are connected under the earth, and so you can't actually see the connection. The Sacketts were a couple who backfilled some wetlands on their property in order to build a house and were halted by the EPA and the Army Corps of Engineers under this authority that they had under the Clean Water Act to regulate wetlands. They said you can't backfill on those wetlands because they're connected to an interstate waterway. They were connected under the ground to this interstate waterway. The case went to the Supreme Court, and this was not the first time the Supreme Court had considered the EPA's authority under the Clean Water Act. This is kind of a continuing theme over the last 50 years to determine exactly what the Clean Water Act means when it gives the EPA authority to regulate navigable waters of the United States, right? How do we interpret that term? Well, part of the interpretation of the term was that the EPA says, and the statute actually supports the idea, that the EPA can regulate waters that are adjacent to interstate waterways, which would include wetlands that are connected over land and wetlands that are connected under land, at least by the EPA's reckoning. Well, the case went to the Supreme Court, and the Supreme Court said otherwise. What the Supreme Court said was that the Clean Water Act authorizes the EPA only to regulate wetlands insofar as there's a continuous surface connection, and otherwise a visible connection between the wetlands and the interstate waterway, which meant that the EPA could not regulate the wetlands in this case, in the Sackett's case. Now, that's a pullback from the EPA's authority under the court's most recent ruling on this that said that the EPA could regulate wetlands that had an underground connection to an interstate waterway. And so we're seeing the court pull back on the authority of the EPA under the Clean Water Act in a pretty dramatic way, but at the same time reining in the administrative state and grabbing power for itself in ways that we just discussed. And I can say a little bit more about that in Q&A if you're interested, but I think in the interest of time, I'll talk about my second case. This is the Biden student loan case that a lot of us were very excited about. So the Biden administration granted student loan relief under the HEROES Act of 2003. The HEROES Act is an act that Congress passed in the wake of 9/11 that authorized the administration to take action in a national emergency. In this case, that the administration could, and here's the key language, waive or modify terms of student loans such that student loan borrowers were not put in a worse position after the national emergency, in this case, the pandemic. The Biden administration implemented this. States and individuals challenged it. There were significant standing issues. I'm not going to address those right now, but to suffice it to say that the court easily could not have issued this ruling if it didn't want to on standing grounds. It nevertheless reached out to issue this ruling and to strike the Biden administration student loan program. Now, here we've got an example of this kind of hypertextualism that I was describing a moment ago, where the court really parses the words waive or modify and then parses the phrase waive or modify and says that the Biden administration program neither waives or modifies nor waives or modifies as a complete clause. It doesn't do either one of those things. It changes the law. In support of that ruling, the court relied on its major questions doctrine. And if you haven't been following this, the major questions doctrine says that when an administrative agency seeks to take an action that has important political and economic significance, the administrative agency needs clear guidance from Congress. Now, there's some question about how this major questions doctrine squares with textualism, right? Because if Congress delegates authority, the major questions doctrine might get in the way of that delegation of authority. Justice Amy Coney Barrett seeks to reconcile the two in a concurrence in the opinion, but the upshot is that the court seems bent on using this new major questions doctrine, both in the student loan case and in the Sackett case, in a somewhat different way, to rein in administrative agencies and restrict their powers dramatically. But again, not restricting all powers. I suspect that what we're going to see from this court is that it will restrict administrative agencies when they seek to exercise disfavored powers by the 6-member majority justices on the court. And so we can look for more of this next term. There are 2 cases I'm keeping an eye on. One, testing the Chevron doctrine, and the other, testing the funding mechanism for the Consumer Financial Protection Bureau. I think those are going to be important cases, and we're going to look for this trend to continue. Thanks.
Next is Michelle García, who's the Deputy Legal Director of our co-sponsor, the ACLU of Illinois.
Thank you, everyone. So I get the pleasure of talking about the civil rights win that we had at the Supreme Court. Everyone cheer. I'm talking about Allen v. Milligan. This is the Section 2 Voting Rights Act case. In a 5-4 opinion, with Roberts writing for the majority, our 3 liberal justices joining, and Kavanaugh joining in part, they affirmed the District Court of Alabama's preliminary injunction that the state's redistricting map likely violated Section 2 of the Voting Rights Act. Now, how did this case get to the Supreme Court? Well, there were 3 cases brought by Black voters and the ACLU, and NAACP LDF that argued that the state's map, which hadn't been really changed for about 20 years, the map for redistricting 7 seats of the House of Representatives diluted the Black vote, who were 27% of the population. The ACLU and our partners argued that the HB1 map broke up the Black Belt, a community of common interest, which was a rural area of 18 counties that had majority Black populations as voters. And this map the state was trying to use for elections violated the Equal Protection Clause of the 14th Amendment and Section 2 of the Voting Rights Act. At the injunction hearing on January 2022, a 3-panel judges at the District Court of Alabama agreed. And there were 2 Trump appointees. And what they considered was an enormous amount of evidence, including the plaintiffs put forth 11 possible maps, which would have created and included an additional majority Black district. Now, the state's plan actually had one other majority Black district, but that was a result of a prior civil rights case under the Voting Rights Act in 1992, not something that they had actually willingly done. So let's look at the Roberts opinion. First, Roberts talks about the history of the Voting Rights Act and the 15th Amendment. And he spends quite a bit of time talking about the precedent. 37 years, the Supreme Court has applied Thornburg versus Jingles, which puts forth a 3-part test that plaintiffs have to prove to show that the vote has been diluted. He applies the test and agrees with the district court and spends a lot of time really getting into the details of expert testimony and information about the history of Alabama. Like, for example, for 115 years, they never had a Black representative, starting from Reconstruction to the 90s. But then he says, quote, "The heart of the case is not about the law as it exists. It is about Alabama's attempt to remake our Section 2 jurisprudence." And he says Section 2, since 1980, when there was a congressional amendment, has been designed to address voting and its disparate impact, the discriminatory effects. And what Alabama is trying to do is to undermine that. What did Alabama argue? Alabama argued for this race-neutral benchmark map. They said plaintiffs have to calculate a map where race is not included at all. Take race out as one of the factors. And then they have to compare that race-neutral map, supposedly, to what the state map is. And if there's a difference, then plaintiffs must show that that difference is due to race. Okay, totally different than what is under the act and what this 37 years of precedent has required. So Roberts says, no, Section 2 demands consideration of race. And by taking race out of the equation, you're putting a burden that the plaintiffs cannot meet and that Congress didn't ask them to meet. He says that we all know by asking them to prove that difference, you're actually asking them to prove intentional discrimination at a standard that's harder than Arlington Heights. And we all know under Arlington Heights, to prove intentional discrimination, race just needs to be a motivating factor. It doesn't have to be the sole factor for this particular decision. Alabama puts forth a couple other arguments that Thomas in his 48-page dissent really loves. Alabama says, look, based on the text of the Voting Rights Act, to deny or abridge practices or standards or procedures that deny or abridge people's right to vote on the basis of race really only means access to the ballot, right? It doesn't include redistricting. And Roberts says, no, for 37 years, we've said it's included redistricting. And the other argument that they make is that Section 2 is unconstitutional. because it requires this consideration of race, right? Race is one of the factors that goes into making the map. And that the 15th Amendment prohibits the consideration of race in voting. Well, Thomas really Roberts really directly calls out Thomas and says, no. The language of the act has always been about including redistricting. It's always about including these sort of larger things that can cause this discriminatory effect. And that even if the 15th Amendment prohibits purposeful discrimination, that doesn't mean that Congress can't outlaw voting practice that have discriminatory effects. And he doesn't believe that Section 2, as interpreted by the longstanding precedent, exceeds remedial authority of Congress. So you might be thinking, how does this case square with the two cases that we just heard? The difference here is that we have a statute, we have, and Kavanaugh actually says it in the concurrence, that the Supreme Court is more willing to give deference to a statutory interpretation than something that's just a pure constitutional challenge, and more willing to kind of uphold the precedent that has been there. But Roberts also really spends a lot of time looking at the legislative history. And in 1980, when Congress took action after the Supreme Court had ruled that the Voting Rights Act only prohibits intentional discrimination, Congress took action and added a whole section that outlined the tests for how to prove discriminatory effects. And so he said, look, if this is a situation where we've got it wrong, Congress could have taken action to fix it. And they didn't. So we got it right. So just to kind of give it an in point on what's happening in Alabama. Have you been watching the news? Okay, I see some winces. So even though we won at the Supreme Court, and the 3-panel district court had already ordered the state to redo their map and add that second voting district, Alabama's legislature passed basically the identical map after the Supreme Court ruling. And the U.S. Department of Justice has filed a statement of interest asking that the court, that the court find that this map violates the Voting Rights Act, and order them to put in one that complies with the act, or take it on their own authority to implement a remedial plan. So that will be going forward. They'll be hearing around this idea very soon. Thank you.
Thank you, Michelle. We are fortunate on this panel to have not one, but two former solicitors general of the state of Illinois. I should have mentioned that, Carolyn and Mike. They'll both be talking about cases that have some significant implications for state and local governments. I'm especially happy to have Carolyn back on this panel after a number of years, because Carolyn was one of the leading scholarly and commentator voices. You would have seen her quoted all over the place, and she published significant scholarship about the case she'll be discussing next.
Thank you very much, Stephen, and thanks to all of the sponsoring organizations and people who helped make this happen. I really am happy to be back here. I'm going to be talking about Moore versus Harper, which is the case involving what's been called the independent state legislature theory. And I'm going to start by giving you a little bit of background about where that theory comes from. The good news is it was largely, although not completely, rejected in Moore versus Harper, and that is very good news. And I'll talk a little bit about where I think the landmines may yet lie, because they do still exist. And I will just say, I think it was inevitable that there would be some after this case. I don't think there was any chance, even going in, that this was going to entirely close the door to the types of challenges that could be problematic under this theory. States, of course, as you know, operate the election system in our country. They often delegate to local governments, but it is not a federal function. It is a state function, although it is subject to some federal regulation. the key language, constitutional language, that the independent state legislature theory relies on is language in both Article 1 and Article 2 of the Constitution that singles out state legislatures as an entity that's involved in making certain types of decisions. So in Article 1, the Constitution says that the state legislatures can regulate the time, place, and manner of congressional elections. Congress can override, but the baseline is that the state legislature can regulate. And Article 2 says that presidential electors are appointed in such manner as the state legislature shall decide. Those are modest paraphrases, but that's basically what those two clauses say. So the argument that people have made based on that language is that because the Constitution singles out state legislatures and gives them this particular set of duties / powers, the state legislatures are acting, when they act pursuant to those clauses, completely independent of all other state apparatus, including state constitutions, including ordinary forms of statutory interpretation. The idea, it goes something like this: because it says state legislature, a state constitution can't then tell the legislature that it is in some way constrained by that constitution. Now, this is a little hard, I think, for lots of people to get their minds around, because frankly, it's kind of wacky, right? That's not the way we work. The legislatures are creatures of their state constitutions. They would not exist but for their state constitutions. And the overwhelming weight of historical practice, historical evidence, is to reject this particular theory. There were constitutions that were implemented in Delaware and in Maryland minutes after, well, maybe like 2 years after the 1789, that included specific language regulating both federal and state elections, for example. There are numerous state Supreme Court cases, federal cases, but nonetheless, periodically, this idea has popped up. It has popped up in the early 20th century when people tried when litigants claimed that governors couldn't exercise vetoes over decisions, laws passed regulating federal elections. And the Supreme Court said, no, if the Constitution says that that's part of the lawmaking process, then the governor can exercise a veto. Likewise, in the state of Ohio, there was a constitutional provision that allowed the voters to reject through a referendum any law passed by the state legislature. And the Supreme Court said, yeah, that can apply to a redistricting map. There's no reason why it couldn't. That's what the state constitution said. More recently, though, this argument has popped up in the election of 2000 in Bush versus Gore, and in the earlier case, Bush versus Palm Beach County, and in the 2020 election. I could go into a lot of detail, and I'm happy to in the Q&A about precisely what happened in those different elections, but I'll just say that during the 2020 election, there was a significant danger that the Supreme Court was going to say that certain states like Pennsylvania had, the courts in those states had exceeded their authority because of the independent state legislature theory. There were 4 justices who said versions of that. 3 of them really went all in: Gorsuch, Thomas, and Alito. Justice Kavanaugh started out embracing this idea, but he kind of backed off. And that turns out to be significant in Moore versus Harper. Moore versus Harper itself is not a case arising from the 2020 election. It's a case about redistricting. It's the redistricting map passed by the heavily gerrymandered North Carolina legislature. And the North Carolina Supreme Court said that after an extensive historical analysis, that extreme partisan gerrymandering violated the North Carolina Constitution. At the time, the North Carolina Supreme Court was controlled by Democratic nominees or justices. Republican leaders of the legislature appealed to the Supreme Court. while that appeal was, and the Supreme Court took the case. When the Supreme Court took the case, that was very nerve-wracking for those of us who've been following on this issue. But in my view, it was actually very important. It was important that the court take the case. It was important that the court largely decide the issue, even though I never thought they'd completely decide it, when we were not in the middle of an election. That was a very important time for that to happen. Lots of stuff happened in North Carolina while the case was pending, including that the control of the North Carolina Supreme Court switched parties, and they basically overruled the first case. So there's all kinds of jurisdictional questions in the case, which I'm not going to talk about now at all, but you can ask me about it in the Q&A. What the Supreme Court said, 6-3 or 6-2, 6-3, they said we have jurisdiction. 6-2, they said the independent state legislature theory makes no sense. And they recited all of this history that I've already discussed and mentioned. They talked about why it makes no sense. They distinguished a couple of other cases that people have claimed support the ISLT, but they rejected it. This is very good news. What it means is that state courts can continue to enforce pro-democracy provisions of their state constitutions when it comes to federal elections, and state constitutions tend to have more of those than the federal constitution does. So this is good. It also means that heavily gerrymandered legislatures don't have complete free rein to implement entrenchment also at the federal level. The door that was left open is that the Supreme Court said, well, federal courts still have some obligation to review, and that where a state court has gone beyond the ordinary bounds of judicial review, or the bounds of ordinary judicial review, uses both phrases, we might have to step in. Nobody knows exactly what that means. I think that the signals are good, that what that means is a pretty narrow range of cases where a state court really just goes off the rails. But we don't know for sure. I can talk more about why I think that the signals are good, but we don't know for sure. And Justice Kavanaugh in particular, perhaps defending his earlier work in Bush versus Gore, wrote a separate opinion saying that leaving open this or exploring further this idea that federal courts might have to review how good the judging of state courts is when they interpret their own constitutions and their own statutes. So there will be more to come.
Thank you. Mike.
Thanks, Carol. Thanks very much, and thanks everyone for being here today. It's such a pleasure to be back in person in this room.
We are very grateful to Mike, who is the person who has to pull the levers and run the traps and do whatever is necessary with the powers that be at Mayor Brown to secure the sponsorship and the nice lunches you all have.
It is my pleasure to do so. Thank you, Steve. No, it's my pleasure, and it's the firm's pleasure. It was an easy lift internally. So I actually also have the pleasure of talking about a case where we have a civil rights win, 7-2, in fact, in a civil rights win. And also then I'll talk a little bit about a second case as well, as Steve mentioned. But let me start with Health and Hospital Corp of Marion County versus Talevski. And this case starts out with Mr. Talevski. He was an elderly gentleman suffering from dementia, and his family placed him in the Valparaiso Care and Rehabilitation Home, which is in Indiana, and it's owned ultimately by the county of Marion County, Indiana. So it is a government entity, and this will matter for reasons we'll see in just a moment. Sadly, as soon as Mr. Talevski was admitted, things became much, much worse. He started to exhibit loss of faculties beyond what he'd been experiencing. And the family, through their own neurologist, concluded correctly that the facility had actually been giving him drugs to sort of sedate him. It's chemical restraint is the term, to make him, easier for them. And but in the process had made his condition far worse. He recovered as they withdrew that medication, but things didn't end there. The facility started sending him for care to another facility 90 minutes away, further from his family, and ultimately stopped at one point taking him back and said, no, you're going to stay forevermore going forward at this other facility. And they did so without notice to the family. Well, both of these things, chemical restraint and forcible move without notice either to the resident or the family, those are both violations of the Federal Nursing Home Reform Act, signed in the 1980s. And what's interesting about this act, among other things, and we'll talk about it in a moment, but critically for purposes of this case, is it was passed pursuant to Congress's so-called spending clause authority. Now, this will probably ring bells for many in the room, but perhaps not all. So we're used to the various fonts of legislative power that Congress exhibits. We're familiar with the Commerce Clause or the legislative provision of the 14th Amendment, for example. Spending clause is what happens, and it happens quite often, which is why this case is so significant. The spending clause where Congress says, look, you can take federal money, but if you do so, you have to live up to a number of federal obligations. People always take the money, and therefore they have to live up to these obligations. Well, in this case, the nursing home took Medicare and Medicaid funding. Medicaid is the one relevant to this particular case. They took Medicaid funding, and therefore they had agreed to live up to the various obligations set forth in a fairly comprehensive state-federal regulatory scheme that's put together under the Federal Nursing Home Reform Act. Well, as relevant here, there are two provisions. One that prevents chemical restraint, another that prevents forcible move of the patient or the resident without notice to the family or to the resident. So both were violated here. Now, the statute, though, doesn't include a private cause of action. There's no provision that says you can sue for damages if any of these rights are violated. But given that this particular facility was owned by the government, by the county of Marion, it's a state actor. And so the family sued under 28 USC section 1983. Now, this is a provision that's 42 USC, provision familiar to all of us. We think of it as a civil rights statute, right? Oftentimes that's how it's used. But in relevant part, it provides that if there's a state actor that subjects anyone to, quote, the deprivation of any rights, privileges, or immunities secured by the Constitution and laws of the United States, then they shall be liable under Section 1983. And so the claim here was that these two provisions are provided by U.S. law, and therefore we can bring a Section 1983 claim for damages to enforce the violation or to seek compensation for the violation of those two provisions. Well, the first line of defense for the defendants in this case is that basically laws doesn't mean all laws. It should be all laws other than spending clause laws. And the reason for that, there was a historical argument made that spending clause laws are really like contracts. The government offers money, the recipient here, the nursing home takes the money, and in exchange, they have to live up to certain obligations, and the residents are basically third-party beneficiaries of that contract. And in the 1870s, they argued, third-party beneficiaries didn't traditionally have the right to bring lawsuits for damages in court. Justice Jackson, who writes for the 7-justice majority, rejects that out of hand, in part based on an amicus brief provided by some contract law professors that explain that that isn't actually true, that you could, in many cases, bring such claims in the 1870s. And basically, Justice Jackson says correctly, when we let the common law trump the plain language of a statute, we do that only in cases where the common law is, in her words, firmly rooted. And here we have at best ambiguity. And she adds to that, look, contract probably isn't really the best framework for looking at this anyhow. Congress in the 1870s would have thought, like we do today, of Section 1983 in tort, not so much in contract. What I'd like to pause on for just a moment is not only the kind of quick rejection of this, but Justice Jackson's opinion provides multiple pages of significant history at this point about the 1870s enactment of Section 1983. And it paints a picture, a very vivid picture of the post-Civil War injustices that Black Americans faced that prompted President Grant and Congress to pass what we now have as Section 1983. And I think this is significant because it marks, and this is not the only case this term in which this has happened, I think it marks a beginning, what we're seeing, Justice Jackson developing a well-earned reputation quickly for using history, the same periods of history, colonial, mid-19th century, that have often been used in the service of what we would, for lack of a better term, considered more conservative outcomes in the service of more progressive outcomes. And I suspect that will continue. I think she has taken that mantle on. It's a very interesting, I think, counterweight to the way in which history has so often been used by the court in recent decades. So more, we'll just have to keep our eyes open on that. But I thought it was significant. It's really worth reading those couple of pages of the opinion for that reason alone. So once that hurdle had been cleared, and laws continues to mean all laws. And that's, I think, why you have the textualists easily on board that part of the opinion as well. The court goes on to apply a test that's been around since the early 2000s from a case called Gonzaga University that basically tries to figure out with these spending clause cases, would Congress have intended to permit a private cause of action under Section 1983 for the rights being created by this newer, in this case, 1980s statute? And the majority concludes that those two Gonzaga factors are also easily satisfied here. The statute speaks of these two provisions, the anti-restraint provision, the notice requirement for moving a resident, both in terms of rights of the individual. That kind of language is used. And so it seemed clear these were intended to be rights held by the individual, not just language to guide the federal government in deciding where to spend its funding and where to withdraw its federal funding. And at the same time, and this was a little bit harder for the majority, I think, and this drew some separate writings and concurrence, but the court also finds that there's nothing in the statute, and this is the second Gonzaga factor, there's nothing in the statute to suggest that there's anything inconsistent between allowing a private cause of action in this particular case and the otherwise fairly comprehensive state federal regulatory regime that the statute creates. I think traditionally there had been, and certainly the defendants had argued that comprehensiveness of the regime alone was enough to suggest that don't introduce a private cause of action. Everything is covered by this detailed state federal regime already, which includes things we're familiar with from the news, inspections of nursing homes and things like that by state and federal officials. And the court rejects that. The majority rejects that comprehensiveness alone is enough to say there is inherent tension. So I think if anything, that bar is a little higher in a way that favors plaintiffs going forward, seeking to take rights created by spending clause legislation and bringing it under Section 1983 for damages. Again, assuming your defendant is a government entity, always a key threshold for Section 1982. So that leaves me just a couple of minutes, if I'm calculating correctly, to quickly touch on a second case. And this one does implicate, as Steve said at the outset, sort of state rights, also federal rights and tribal rights. This is a case under the Indian Child Welfare Act. It's called Haaland versus Brackeen. Many of you may have heard about the case. It is a tome for those who are looking to read it. But in essence, what this case, and I'll use the term Indian, that's what's used throughout the opinion and in the title of the act, what it basically was intended, what the statute was intended to do was to make it harder to remove children from Indian families and place them with families that were not part of that tribe or secondarily any other Native American or Indian tribe. And it did so through a number of provisions. In the context of involuntary removal of a child, situations where perhaps there was a fear of danger to the child, so you have an involuntary removal circumstance. Under those situations, there was a very, very high burden for removal, burdens that would not exist traditionally under state family law in cases like this. For example, there needed to be showing that active efforts had been made to, either remedial services or rehabilitative services that would have kept the child in the child's original home. There also needed to be showings that there'd be serious emotional or physical damage if the child were removed. Very high showings required that again, state law would not traditionally require under one of these proceedings, which occur in state courts under state family law traditionally. The other provision, this applied to not only involuntary removals, but also to circumstances involving voluntary, adoptions where all parties agree. Even there, the tribes were entitled to notice, the child's tribe was entitled to notice and to intervene to pursue a transfer of the child to, and then there's a list of priorities in the act, someone within their tribe, within any other Indian tribe. It doesn't have to be the same tribe. And so even in circumstances where the biological parents and adoptive parents had agreed on the adoption, the tribe could intervene and say, no, we think the court should instead place the child with our tribe or a couple that's willing in another tribe. So these provisions were challenged by the state of Texas, and they were also challenged by a number of individuals involved in these child custody hearings. And the court rejected all of the constitutional challenges. And so this marks yet another, certainly a victory for federal power in this space. The court rejects a number of the challenges on the theory that Congress has sweeping authority to legislate when it comes to Native American tribal issues. They cite 4 different constitutional bases, including the Indian Commerce Clause and the Treaty Clause, in support of broad congressional authority in this space. But the court then also goes on to deny a number of other challenges, anti-commandeering challenges, for those who are 10th Amendment mavens in the room and love their anti-commandeering. These are theories that states cannot be required to do things under federal law without resources being provided by the federal government to do those things. The court struck all of those down as well, basically saying that the burdens being placed on state courts in being required to follow the act, those don't amount to the kinds of burdens. Those are traditional things that we ask state courts to do in enforcing federal law. For those and other reasons, the anti-commandeering theories were rejected. And then there were a couple rejected at the end. Standing, a theme of the term, like so many terms of late, rears its head again. And we also see that a couple of the theories are also rejected, including equal protection, which is probably the one that comes to mind for many most in talking about the case. The notion that you're using tribal membership, for example, and ethnicity to distinguish between and among potential parents. That was, the court doesn't reach on standing grounds. And likewise, there was a non-delegation theory that some of the power given not to the federal government, but to tribes themselves in deciding what the priorities would be for placement of children, that was sort of boundless discretion. And so, we're used to thinking about non-delegation in terms of giving power to federal agencies. But in this case, the theory was that it was boundless authority to tribes. And that too was avoided by the court on standing grounds. So yet another win, I think, for fairly broad tribal authority. A loss for the state, if you're thinking of it that way, in terms of their courts do have to adhere to these. It trumps state family law, but also a sweeping win, I think, for federal authority to regulate in this space. Thank you.
I will close us out by talking about the 303 Creative versus Elenis case. And I'll leave it to you, when I get done, to determine whether or not it's a victory for civil rights or not. I think it's an argument that can go both ways, as I'll try to illuminate. So you might recall a few years ago, the court decided this case called Masterpiece Cake Shop. You had a baker in Colorado who wasn't just a baker; he was sort of the Bernini of buttercream in his own mind, and he would create cakes for weddings. And he basically said, when I create a cake, it's essentially I am expressing my views about the rightness and the holiness of that wedding. And he refused to bake cakes for same-sex couples. To sort of make a long story short, the baker won, but on a very narrow ground having to do with the way the case had been litigated in Colorado, and the court skirted the big First Amendment questions in that case. Well, the court came back to those questions this year and gave us a fairly resounding answer about the meaning of the speech clause in cases like this. So this case, 303 Creative, comes also from Colorado. This time it was not a baker, it was a web designer. It was somebody who's in the business of doing websites. And she said, I want to go into the business of doing websites for weddings, but it is against my religious beliefs. I would not be able to do them for same-sex weddings. I'm happy to serve LGBT people in any other way. I just can't do same-sex wedding websites. There was, to continue with the theme, an interesting standing issue in this case. I'm not going to spend a lot of time on it. She wasn't yet doing the wedding websites, and there was kind of this weird dispute about whether or not she had been contacted and asked by somebody in a same-sex couple to do one of these websites. I am in the camp that thinks that was sort of irrelevant. Pre-enforcement challenges to laws based on their constitutionality are not uncommon. The web designer made no secret of her plans to not serve same-sex couples. I think it was inevitable that somebody would, she was going to start doing this and somebody was going to challenge her refusal. So I'm not bothered by the standing questions there. And although this clearly is about her religious objections to serving same-sex couples, the court relies entirely on the speech clause of the First Amendment, not on the free exercise clause. And I think that's in part because that is a strategy that has increasingly been developed and pursued by litigants representing conservative religious people opposing gay rights and other civil rights laws to for doctrinal reasons, the arguments available under the speech clause are more robust and more friendly to those interests than those available under the free exercise clause. The ultimate principle, the court said, is that this requiring the website designer to comply with the civil rights law in Colorado and serve same-sex couples in their weddings would be what in First Amendment terms is called compelled speech. It would be the government forcing a citizen to speak a message or to carry a message that is against that person's conscience. And it's well established in First Amendment doctrine that government can't compel the speech of a citizen against their will. So the court has held that speech for commercial motives, such as a motion picture that represents a director's vision that is, for which admission is charged, that's protected under the First Amendment. But this is the first case, so far as I know, to hold that someone who is doing what I would call speech for hire or work for hire is covered by the First Amendment. My initial instinct is to say, she's just carrying out the vision of a client. I might, as a citizen, have a viewpoint or something I want to express, but when I hire somebody, they are just my agent carrying out my wishes. It is not their speech, and it can't be that their speech is being compelled. Yet, nonetheless, that's what the court says. The court, sort of adopting the arguments of the website designer's attorneys, sort of notes she has to muster her creativity, her enthusiasm. She vets prospective projects to determine whether it is one she is willing to endorse. She will consult clients to discuss their unique stories as source material. She will produce a final story for each couple using her own words and her original artwork. Each website is customized and tailored. And so the court basically says this is her speech, even though she is doing it for a profit motive. It is, in a sense, speech for hire. It is still her speech and thus comes within the protection of the First Amendment. I think one of numerous weaknesses in Justice Gorsuch's opinion for the majority in this case is his refusal to sort of explore or deal with questions like, well, what if a business owner declines to do a project or express a message based on racial beliefs or beliefs about a group's ethnicity or something else? Is that a different case? Can someone refuse to engage in a project for an interracial marriage because that goes against their religious beliefs? So apparently the answer has to be yes under this decision, because the court doesn't announce any sort of limiting principle. So I said at the beginning, I'm a little ambivalent about whether this is a civil rights win or not. I have tended to not like these arguments, to see that somebody who is doing speech for hire is protected by the First Amendment. I had real problems with the idea that the cake baker is engaging in expressive activity. I think a web designer is somewhat more plausible. But here's the dilemma, I think, for progressives, and I'm curious to talk with you after this if you have any thoughts on this. If this principle is wrong, then what protection would there be for the gay or the lesbian or the transgender web designer that refuses when a church-based group comes in the door and wants them to work on a project that communicates an anti-LGBT message or any other message that they disagree with politically? I think instinctively we would all say, well, of course, that person has the right to refuse that business. But what if the church could say, but you're engaging in discrimination on the basis of religion? We're a church and we can claim the protection of a civil rights law that says you can't turn us away because we are in the business of religion or because we're a church. And the web designer might say, well, I'm not turning you away because of that. I'm turning you away because of I disagree with your message. Well, that's exactly what the web designer in this case says. I'm not turning you away because of your sexual orientation. I will gladly serve you in other ways. I just can't get my arms around endorsing, doing a website that endorses and celebrates a same-sex marriage. And so, as I said, I think I was sort of given pause when I saw the Foundation for Individual Rights and Expression, FIRE, organization much in the tradition of the ACLU in terms of being a neutral arbiter and insisting on neutral principles for free speech, came out and praised this decision. I think a final word, I think the biggest problem with this case, even if I'm right that this might actually be good because it's a neutral principle that that progressives can claim as well as conservatives, there's also no limiting principle on what counts as expressive. Okay, maybe a website that is inherently an expressive activity, but what about the baker, the florist, the person who engraves the rings, the singer at the wedding? What are the boundaries of expressive activity recognized by the First Amendment that can provide refuge for claimants in future cases? The court simply refuses to give us any guidance on that. And so I guess the one silver lining is, to the extent we're lawyers or lawyers in training, there may be floods of litigation now testing the boundaries of this principle in the future. So thanks for your interest and attention. And we do have some time. We'd like to honor our commitment to get you out by 1:30, but I think we have some time for questions. And we have a microphone here for those who remember. Oh, I almost forgot the online audience. The secret second word is Ken, that you need to enter into your CLE form to prove you've been listening and attentive all along. Do we have any questions here in the room? This is usually not a shy group. So, okay, right here.
I guess this is aimed at Steve, I think. You mentioned, you would comment on the anti-Chevron case, Loper Bright. What are your thoughts about what might happen?
Oh, this Steve.
So I think the court is going to take a serious swipe at the Chevron doctrine, which means that agencies will have more limited authority to interpret federal law in the ways that they've always been interpreting federal law, and that will be a constraint on agencies' authorities going forward. The other case that I had mentioned is really interesting, and I think we ought to keep our eye on it too. The Consumer Financial Protection Bureau is an independent agency. It was independent because of a removal restriction on a single director, which the Supreme Court struck several terms ago, but its funding mechanism makes it independent as well. It receives its funding from the Federal Reserve, not from a direct appropriation from Congress. And so what Congress has done in this case is, through institutional design, created an independent agency that operates in a way independent of political influences in the White House and enforces consumer financial protection laws. If the court takes away that funding stream and that measure of independence, that will be a serious blow to the independence of the agency and mean that that agency is moving in the direction of being more, I'm going to say, more politically accountable, which seems like, yeah, that ought to be right, but politically accountable in a political way to the White House. And you can imagine then that who's in the White House will directly influence how consumer financial protection laws are enforced in our country. Another question. Alan Neff.
Now you've propped it sort of a follow-up on that same point. How is it that the court gets the idea that it can reject a funding decision by Congress about a particular stream of financing for an agency? Tell us how they do that.
Stunning. It's raw power. right? And we're seeing this not only in the court's rulings, but in the rhetoric that we're hearing from justices. For example, Alito's interview with the Wall Street Journal recently. I mean, this is just a court that is all about power at this point. And I had mentioned what troubles me about, there are a lot of things that trouble me about that, but as somebody who watches separation of powers, here you've got an institution that is both part of the separation of powers, but also the police of separation of powers. It's emphasizing its police role these days and grabbing that power without recognizing that it's doing lasting damage to our separation of power system and checks and balances between the three branches.
I should say too that for the folks at home, it is possible to submit questions. We did get one question. It's really not constitutional, and so it's potentially requires some explanation, but I'll throw it out. One person asked, were any of the panelists surprised that the court reaffirmed a general personal jurisdiction via corporate consent in Mallory versus Norfolk Southern Railway? I guess it's constitutional in the sense it involves the due process clause, but any thoughts on the personal jurisdiction case? Mike, you look like you want to say something.
Yeah, I do think a lot of court watchers thought it might go the other way. I think there was a real divide, which is not always true with some of the constitutional claims, particularly in personal jurisdiction. But I think in the last couple of terms, there have been a sort of a little more unpredictability to where the court was going on corporate personal jurisdiction. So,
and this was a case, the outcome made it easier to get personal jurisdiction over a corporation, right? That has
exactly
a kind of minimal presence otherwise in a state.
Yeah, that's exactly right. For folks who may have missed this one, this is where the Secretary of State of Pennsylvania required as a condition of doing business in the state, not being headquartered or incorporated, but doing business in the state, that you consent as a corporation to personal jurisdiction for any lawsuits in state court. I think the real question now is, my understanding is a small number of states have similar provisions. I don't know. I think the big question will be how many states enact such provisions in the near term. I think that'll be
Aziz, we have another online question I'm going to direct to you since it really stems from Students for Fair Admissions. What about other entities and institutions what about employment, both in the public and private sectors, efforts to achieve diversity through employment practices? Are those also at risk because of this affirmative action case?
The argument for that will underlie a coming wave of legal challenges focused upon DEI programs in the private rather than the public sector will turn on the parallelism between the court's constitutional interpretation, which hinges upon an idea of or a certain idea of colorblindness under the Equal Protection Clause, and the importation of that standard into federal statutes that regulate private actors, such as Title VII and Title VI, which was the statute that was at stake in the SFAA case. I would note that the Title VII argument has some support in the earlier Bostock decision, which was a case in part litigated by the ACLU involving discrimination by employers against trans and other individuals on the basis of their gender presentation and sexuality.
Other questions from the room here, from this audience? All right, someone else asks online, Aziz, also a follow-up. What about government contracting? That, in a sense, has already been covered by the Supreme Court in earlier cases, right? Will SFFA have any impact on public or government contracting in the future?
Yeah, I think that's the same. It's basically the same question about the parallel between the constitutional and the statutory standard. I'm not sure that there's any distinction that one can draw, at least under the way that the court has interpreted the parallelism in SFAA.
We have a question there from my friend from IU Maurer School of Law, Richard.
Thank all the panelists for a wonderful presentation. I'm curious, for those of us who are still holding out hope for some student loan debt relief, if the Secretary of Education does not have the authority to waive student loans, even though it's in the statute, will they then have authority under the Higher Education Act just through the rulemaking process instead? Or will this major questions doctrine come back in a year or two's time?
So just by way of background, the Biden administration, in order to implement student loan forgiveness, has pivoted now to the Higher Education Act, which provides the administration alternative authority to do exactly the same thing under a different statutory provision, but it has to go through notice and comment rulemaking. So the administration has commenced that process. We expect that they'll come out with rules forgiving student loans in much the same way they did in the first round under the HEROES Act. But my prediction is that this will be subject to litigation just like it was under the HEROES Act. And I think your question is spot on. Will this also fail under the major questions doctrine? And I think that that is likely. I haven't looked carefully enough at the Higher Education Act and the arguments around major questions doctrine with regard to that particular statutory authority. But given the trajectory of the court on major questions doctrine, which it expanded incidentally in the Sackett case, the Clean Water Act case, in an entirely new and surprising way, I think we're going to see this doctrine really explode.
I'd like to ask the panelists, and I didn't prepare them for this, but I think, Steve, you mentioned a couple of cases next term you're looking at. Since this is a review rather than a preview, we're not focused necessarily on the next term, but I'm curious if any of the other panelists have a case that they're watching or that they're worried about that is scheduled to be argued and decided in the coming term. Michelle, Carolyn, anything further on voting rights in the pipeline right now?
Yeah, there's a case from South Carolina having to do with a racial gerrymandering challenge. The Supreme Court has not been, the current majority has not been particularly open to the notion that one can even establish discriminatory intent on the part of a legislature when it redistricts, which makes Justice Thomas's argument in dissent in Allen versus Milligan particularly ironic. This is sort of, heads I win, tails you lose. But so I'm nervous about that case. I'll say, in addition to being nervous about the case itself, I think one way in which the Supreme Court has been amassing power, in part in the way that Steve describes, has to do not only with the way it's doing statutory interpretation and constitutional interpretation and policing the bounds of separation of powers, but the way in which it is not particularly respectful of factual findings by district courts. It just sort of pretends they don't exist when they don't like them. I mean, the court has always played a little fast and loose with the record and has always been willing to go beyond the record, especially when there's an amicus briefs that present outside information. And I think to some extent that's always been appropriate, but there is a particularly extreme version of that happening. One particularly strong example of that might be from the case a couple of terms ago involving the football coach who, according to the majority, was engaged in private prayer, despite the existence of, as Justice Sotomayor showed in her dissent, pictures showing him in the middle of the football field, surrounded by other people, including all of his players.
We have another question there, please.
So it seems like the court could at least make a somewhat plausible argument that they're better able to make decisions based on history than the executive or the legislative branch. But it seems that now they're deciding that they are better scientists than the than Congress or the executive branch, when it's clear that, I mean, they're all lawyers. They are the least qualified branch, in my opinion, to try to make scientific decisions. But given that they want to make policy decisions on things like birth control and abortion, are you afraid that they're just going to decide that they're scientists too, and then just go off, or either that or come up with bogus experts that they'll decide, well, we believe this person who says he's a scientist, even though 99.8% of actual scientists thinks the guy's a crank.
Any thoughts on that? It was more a statement than a question, but that's all right.
I can make it into a question for you, isn't it? I think there's two things to say there. The first is the court's pretty terrible at history. Exhibit A is the Second Amendment decision from last term, which hopscotches as if it was in a children's playground around the colonial and 18th and 19th century history of firearms regulation that's actually quite extensive in order to strike down public carry laws. The second example, Exhibit B, is Justice Thomas's opinion in SFAA, which purports to find an originalist basis for colorblindness. The pivot of Justice Thomas's opinion is a statute, the 1866 Civil Rights Act, which was the motivation for Congress to pass the 14th Amendment, one of the motivations. The idea was, in the absence of the 14th Amendment, the 1866 statute would be unconstitutional. Thomas points to that statute and says, well, this is clearly a colorblind measure, and therefore requires us to read the 14th Amendment in a colorblind way. The 1866 statute says that if you are treated in a way that is not the same as a way that a white person would be treated, you are entitled to a tort remedy. One thing that strikes one about that statute is that if you're a white person, you don't have a remedy under it. It's not a colorblind statute. With respect to science, I think it's worth paying attention to the recent opinion from I believe it's the Western District of Louisiana, invalidating and preliminarily enjoining the Biden administration's interactions with Facebook and Twitter concerning public health disinformation. The district court judge in that case is on public record as doubting the science behind COVID vaccines, and the voluminous opinion in that case bespeaks what one, I think, could reasonably describe as a measure of skepticism bordering on contempt for the scientific conclusions that motivated much public health policy, actually over both the Trump and the Biden administration with respect to COVID over the last 4 years.
One more quick question. Okay.
Just a quick one about the longevity of the court's test for overturning its decisions. In several of the cases that were discussed today, you mentioned that the court had in effect overruled its prior decisions dealing with the WOTUS, and also in the affirmative action cases dealing with Grutter and Gratz, but it didn't say so exactly. Do you have a sense of whether the court has changed the test for stare decisis, assuming that it still cares about its past decisions? I mean, if we're advocates out arguing for circuit courts to retain their decisions, should we still be relying on Casey or other precedent that talks about the workability rules and others that go into deciding whether to overturn precedent?
Well, of course, in the Students for Fair Admission, the court didn't acknowledge that it was, for all practical purposes, gutting or overturning Grutter, and so it didn't go through that traditional analysis. And isn't the Roberts Court, and especially Chief Justice Roberts, known as being kind of a master of all but overturning a decision without saying so,
Yeah.
without admitting to doing that?
Yeah, I think that's one of Robert's hallmarks. I think I would say Casey, as precedent on precedent, is certainly viable in the circuit courts. What Dobbs says is everything was just so wrong with respect to Roe that and Casey got it wrong on workability. So it's not that the standards are wrong, but just they made a mistake. Obviously, I profoundly disagree with those statements. But I do think it's notable that the court relied so heavily on precedent in Allen versus Milligan. I mean, there was a lot of concern that they were going to throw out this 37 years of precedent. And in Moore versus Harper, although the precedent was less clearly on point, the extraordinary weight of precedent and historical practice all pointed in the direction that the court went. Again, that was a Roberts opinion. So I think he may be, and he's no friend to voting rights. I mean, part of what made Allen versus Milligan such a sweet victory, frankly, is that he wrote it and he's been trying to destroy the Voting Rights Act for his whole career. On the other hand, I don't think we should get too excited. And like, there's been some commentary about how the court is tempering itself and we shouldn't worry so much. I don't think that at all. And that the fact that in some cases the court hasn't overruled itself when it could have doesn't mean that they won't when they want to.
Just wanted to add on to what you were saying about that case. You know, it's interesting. The precedent that Roberts does cite really spends a lot of time focusing on cases where minority voters haven't won. And he says under the Voting Rights Act, it's really hard to bring a Section 2 case. And I think what ultimately drove this opinion was the factual record. There were thousands of pages, 17 witnesses, tremendous 3 days of hearing that brought this case together. A Herculean effort by the ACLU, our partners at NAACP, and our clients to prove that historically Black voters their votes have been diluted for decades. And so I think he had no choice, but he spent a lot of time saying, yeah, you got it right, but it's really hard to make the case. And that's how he was able to say, oh, this provision of the Voting Rights Act really is really pretty narrow. And this argument is really pretty narrow. And I think to your support, he's not a fan of it, but that's what drove him to finding that opinion.
Thank you. So it's been lovely to see all of you in this nice full room. And until next year, thank you for coming. Thanks to the panelists. Thanks to Mayor Brown, ACLU, PILI, and ACS. See you next year.